When we look at history, we often focus on the big sweeping declarations, right, or the iconic moments. But I've been looking through some of South Africa's post-apartheid legislation recently. And what truly struck me is how some of the most, pivotal laws aren't about those grand statements at all. They're about solving very specific, often urgent, and deeply human problems during these huge moments of national change. So today, we're taking a deep dive into one such act, the Defence Special Tribunal Act, Act 81 of 1998. We've got a consolidated version of this act here, and our mission really is to cut through any legal jargon. We want to understand its true purpose, how it actually functioned, on the ground, and why it mattered so much for South Africa as it was building a new nation. So whether you're just generally curious about how countries manage these big transitions, or maybe you're keenly interested in the architecture of law itself, this deep dive should be for you. Okay, so let's unpack this a bit. Imagine a country emerging from decades of division,
trying to knit together disparate, even formally opposing military forces into one single unified national defense system. I mean, that's just a monumental undertaking, isn't it? Full of complex human and logistical challenges, and inevitably disputes are going to rise about pay, pensions, ranks, job roles, maybe unfair treatment. This act, it seems, was designed specifically to address those kinds of issues, providing a critical safety net during what must have been a really fragile period.
Exactly. And what's truly fascinating here is how incredibly strategic and, almost surgical this legislation was. It wasn't meant to be permanent, you see. Instead, it was a temporary, purpose-built tool designed to navigate a very particular high-stakes set of challenges during that critical transition of the South African military. It's really a brilliant example of how legal frameworks can be crafted to adapt to urgent, real-world necessities, offering a clear, efficient pathway for issues that, honestly, could otherwise completely clog up the system and maybe even destabilize a brand new national institution.
That context is absolutely vital. So let's start with that fundamental question then.
Yeah.
Why? Why was this act created in the first place? What was this huge problem it aimed to solve, and why did it need such a special legal solution?
Right. Well, if we connect this to the bigger picture, the act was a direct response to the profound changes South Africa faced after 1994. The preamble itself points to two major processes: the implementation of transitional arrangements in respect of military institutions, and the rationalization of the Department of Defense. Now think about it. Post-apartheid South Africa had to take what were previously separate armies. You had the old SADF, the liberation movement forces like MK, APLA, and the defense forces of the former homelands, and integrate them all into a single, unified South African National Defense Force, the SAN-NDF. Yeah, and rationalization. That basically meant streamlining everything, from ranks and uniforms to admin structures, pension systems, even things like, shared barracks. It was a Herculean task of nation building, really, merging dozens of different cultures and systems into one cohesive unit. And the Act's own preamble, if you put it in simpler terms, laid out its mission to allow the existing labor court to basically transform into a special tribunal, its job, to quickly resolve disputes coming out of this massive military integration and streamlining. The key words were expeditious procedures, meaning fast, efficient processes just for these specific types of conflicts.
Okay, so not for every kind of legal squabble then. It was a highly targeted fast-track mechanism for disputes directly linked to that colossal restructuring. It must have had to be pretty precise about what kind of dispute it would handle. How did the Act define that? What specific kinds of problems was it trying to tackle?
Yeah, it was quite clear on that. While it used broad language like any dispute or alleged dispute which results from or is attributable to those transitional arrangements or rationalization, crucially, it narrowed the focus right down. Essentially, if you were an employee, and that could be a soldier or civilian staff, and your pay, your benefits, conditions of service, or just your general treatment were negatively affected by this big military restructuring, that was a dispute the tribunal was set up to handle.
Okay.
So we're talking about things like discrepancies in rank equivalency, maybe pension adjustments, changes in job descriptions, or allegations of unfair labor practices as these different military cultures tried to merge. It makes perfect sense, really, because integrating such diverse forces would inevitably lead to countless questions about fairness and parity among personnel.
I can only imagine. And when you say employee, who exactly are we talking about here? Because military institution sounds like it could cover a really wide range of roles. Did it just mean soldiers, or was it broader than that?
Oh, it was definitely broader. The Act defined an employee as Any person who is or was, whether in a civilian or military capacity, in the service of a military institution, the South African National Defence Force or the Department of Defence.
Right.
So this cast a very wide net. It covered everyone from a newly integrated combat soldier to a long-serving admin clerk, maybe a medical officer or a logistics specialist. Essentially, if your livelihood was tied to these military institutions during this massive shift, you were covered. The Act even referenced the interim constitution for the definition of military institution, which is significant.
Why is that significant?
Because that's the foundational legal document that guided South Africa right after apartheid. It really anchors this act to that very specific, crucial period of democratic transition and nation building. It just highlights how important it was thought to be, to leave no one caught in this huge process without a clear path to justice.
That really drives home the unique, complex, and high stakes environment this act was born into. It wasn't just about abstract legal theory, was it? It was about practical, accessible problem solving for potentially tens of thousands of individuals caught in this massive national transformation. Okay, so now that we understand why it existed, let's get into the how. How did this special tribunal actually work? What were its powers and what exactly made its procedures so expeditious?
Here's where it gets really interesting, especially for anyone studying legal mechanisms or, governance in transition. The Act made it crystal clear. For the purposes of adjudicating disputes, the labor court shall sit as a special tribunal.
Okay.
So this wasn't a separate, entirely new court or commission that they had to build from the ground up, which frankly would have been an immense political and logistical challenge during such a fragile national moment.
Right. That makes sense.
Instead, they leveraged the existing labor court. And this wasn't just practical, it was, I think it was a strategic masterstroke. By sort of donning a special hat, as you put it earlier, the labor court instantly brought its established legitimacy, its skilled judges who already understood employment and labor law, and its procedural backbone to a brand new, highly sensitive challenge. It minimized disruption and maximized trust in the new system.
So the real insight there isn't just about saving time and resources, though that's important. It's about intelligent resourcefulness, using what's already trusted and established to navigate unprecedented change, rather than whisking the instability of building something totally from scratch. That feels like a powerful lesson in governance. Now imagine you're an employee during this, tumultuous time facing a dispute. What real power did this special hat labor court actually have to resolve your issue? Could it just make recommendations, or did it actually have teeth?
Oh, it definitely had teeth. The Act outlined its abilities quite broadly. For immediate, urgent issues, it could grant urgent interim relief.
What does that mean exactly?
It means if there was an immediate problem, say, a wrongful suspension, or maybe a salary dispute causing extreme hardship, the tribunal could issue a temporary order. To protect the employee while the full dispute was being sorted out, it could effectively hit the pause button on a harmful action.
I see.
And then for final relief, that's the ultimate resolution of the dispute, it could make any order, any court, including the industrial court or labor court, would have been competent to make. This gave it exceptionally broad authority to resolve disputes comprehensively. Everything from ordering reinstatement to awarding back pay or compensation, ensuring affected employees got full and final justice. It wasn't just a suggestion box, it absolutely had teeth.
So the tribunal had serious legal power. And not just powerful judgments, but fast judgments. That was the goal. How did the Act specifically make sure these complex disputes involving military personnel and our livelihoods were handled quickly? How did they avoid it becoming just another slow, bogged-down legal process?
Yeah, that's a really important question about legal efficiency, especially in a period of such flux and, high emotion. The Act addressed this head-on. Section 5 actually empowered the Rules Board for labor courts to create specific expeditious procedures just for this special tribunal.
Bespoke rules.
Exactly, bespoke rules. This meant they could tailor the procedural rules, covering everything from how applications were brought, the forms, the timelines for filing, right through to how appeals would be handled by the Labor Appeal Court. This tailored rulemaking was absolutely key to its functionality. It prevented the normal, often slower legal processes from bogging down these critical transitional cases. I mean, imagine if every single dispute had to go through years of standard litigation. It could have been catastrophic for morale and for the stability of the new SANDF.
Yeah, absolutely. And what about accessing this tribunal? Did employees or maybe their organizations have to jump through a lot of hoops first? Like, did they have to exhaust internal grievance procedures within the military itself before they could bring a case to this special body?
No, and this is a really crucial practical implication, a significant feature for accessibility. The Act explicitly stated that an employee or an employee organization could apply to the special tribunal without it being necessary to make use of or to exhaust any other procedure as required by any other law or the common law.
Wow, direct access.
Direct access. It was revolutionary, really. It bypassed potentially lengthy and complex internal military or public service grievance processes, directly highlighting the Act's commitment to speed and getting straight to adjudication for urgent resolution. It prioritized getting people a fair hearing quickly.
That sounds incredibly efficient and actually quite empowering for the individual. Were there any concerns, though, about bypassing those traditional internal processes? Did it create any new challenges by going directly to a tribunal like this, or is that just seen as a necessary trade-off for speed, maybe a fresh start?
That's a great question, and it's always a balancing act in law, isn't it? While it certainly expedited resolution, you could argue that it might have, maybe in some instances, short-circuited internal learning mechanisms for the new SANDF as it was forming. However, the overarching goal here was stability and confidence during a very, very sensitive transition. The benefits of rapid, impartial external adjudication, especially given the historical context where internal military systems might not have been fully trusted across all the integrated groups, likely outweighed those potential concerns. It was about building trust in the new system, even if that meant external interventions sometimes.
Fascinating trade-off. So direct access was key. But surely there must have been some strict time limits on when an application could be brought. You can't just have these cases hanging open indefinitely, right?
Absolutely. Time limits are essential for legal certainty and, well, for the Act to remain effective during its temporary mandate. It imposed a strict 90-day time limit for applications. That was either from the date the dispute became known to the applicant or the Act's commencement date, which was January 1st, 1999, whichever was later.
90 days. That's quite tight.
It is. However, the tribunal did have a degree of flexibility built in. It could direct otherwise on good cause shown, meaning if there was a legitimate, provable reason for delay, perhaps an employee only recently discovered the full impact of some transitional arrangement, the tribunal could still hear the case. That flexibility was pretty crucial to ensure true justice wasn't denied just on a technicality.
And how quickly were these disputes meant to be resolved once an application was actually made and accepted? 90 days to apply is one thing, but how fast was the actual adjudication supposed to be?
Right. This is where the expeditious part truly shines. The Act mandated that the special tribunal shall adjudicate the dispute as soon as possible, but not later than 60 days after receipt of the application.
60 days for potentially complex labor disputes involving military integration. That sounds incredibly fast.
It is almost unheard of in many legal systems. 60 days.
60 days for a complex military labor dispute. That is an incredibly aggressive timeline. What was the thinking behind setting such a tight time frame, and what kind of pressure did that put on everyone involved, the applicants, the Department of Defense, the tribunal itself?
Well, it put immense pressure on everyone, no doubt. But it was a calculated pressure. The thinking was really rooted in the fragility of that transition period. Prolonged disputes could breed resentment, they could undermine morale, and honestly, they could even threaten the cohesion of the newly formed Sando. So by forcing rapid resolution, the Act aimed to prevent grievances from festering. For applicants, it meant quick answers and closure. For the Department of Defense, it demanded efficiency and prompt engagement. And for the tribunal, it meant a focused, streamlined approach to hearings, maybe fewer lengthy submissions, and a rapid turnaround on judgments. It was a direct legislative commitment to not let bureaucracy stand in the way of justice during a critical national period.
That's truly remarkable. Okay, what about costs? Legal costs can be a huge barrier for individuals, right? Especially those who might have limited resources after such upheaval. Were parties typically on the hook for expensive legal fees?
This is another really vital aspect that made the tribunal highly accessible. It truly leveled the playing field. The Act specified that the Special Tribunal shall not make any order for costs in respect of proceedings under this Act.
No cost orders.
Generally, no. It meant you wouldn't typically be liable for the other side's legal fees, even if you lost, or vice versa. There were only two narrow exceptions. If a party was found to be unreasonable or frivolous in their conduct, basically wasting the court's time without good reason, or if they refused or failed without sufficient cause to attend any pretrial conference or failed to participate properly, but otherwise, no costs.
That's huge. Removing that financial barrier must have been incredibly empowering. I can just imagine someone, maybe a former soldier, feeling very vulnerable after such a big change, maybe out of a job or worried about their pension. This provision essentially gave them a fair shot at justice without fearing ruinous legal bills.
Exactly right. It was a deliberate choice to ensure access to justice without that added burden of potential legal costs. In a period of such uncertainty, ensuring that individuals could bring legitimate grievances without fear of financial ruin was absolutely crucial for maintaining trust and stability among the thousands affected by these military reforms. It signaled that the system was genuinely there to help, not to, profit from their distress.
And what if something completely unforeseen came up during a proceeding? A really unique situation not neatly covered by the established rules. I mean, in such a novel transitional context, I imagine the unexpected was almost the norm.
Indeed. And the Act was surprisingly agile in anticipating this. It actually included an extraordinary procedure. Yeah, this allowed the special tribunal to make such order, adopt such procedure, or deal with that matter in such a manner as it considers necessary or expedient in order to achieve the objects of this Act. Basically, it gave it the necessary agility and discretion to handle truly unique or unprecedented situations that couldn't possibly be legislated for in advance. It ensured that the primary goal, resolving transitional disputes efficiently and fairly, was always met. It's a great example of how a legal framework can build in flexibility for the unknown, acknowledging that you just can't predict every single scenario during a massive upheaval like that.
Okay, so we've seen how this act was this very deliberate, purpose-built legal tool designed for a specific, urgent national challenge. Now let's step back a bit and consider its overall significance.
Yeah.
What's its real-world legacy, especially looking back at it now from a historical perspective?
Right. This raises an important question about the life cycle of legislation, doesn't it? The Act itself in Section 8 was designed from the outset to be temporary. It contained what lawyers call a sunset clause. It was set to cease to have effect on 31 December 2001, although the president did have the power to alter that date by proclamation if it was needed. This built-in expiry date is incredibly telling. It wasn't meant to be a permanent fixture in the legal landscape, but a critical bridge. Its job was to manage that initial, most tumultuous phase of military integration.
Oh.
And importantly, any proceedings already brought before that expiry date would be continued and concluded as if this act had not ceased to have effect. So ongoing cases weren't just abruptly dropped.
So it had a definite expiry date built right in from the start, which, as you say, is quite unusual for major legislation. It really indicates its specific time-bound mission. But it didn't just fade away on December 31st, 2001, did it? We noted in our sources that it was formally repealed much later. Can you maybe clarify that distinction? Between ceasing to have effect and being repealed, it feels like a subtle but important legal nuance.
Yes, you've hit on a crucial point there. The distinction is indeed important. The Act ceased to have effect at the end of 2001. That means no new cases could be brought under it after that date. Its active operational period was officially over.
Right.
But it wasn't formally removed from the statute books, from the laws of the land, until the Defense Laws Repeal and Amendment Act 17 of 2015, and that repeal itself only comes into effect in 2025.
Wow, quite a delay.
Yeah, think of it like this. The special tribunal stopped taking new patients, so to speak, in 2001. But the clinic building itself, the legal framework on paper, wasn't formally demolished from the legal landscape until much, much later. This repeal is basically the legislative equivalent of tidying up after a major project, ensuring all old temporary laws are formally retired once their purpose is fulfilled, and other, more general legal frameworks have fully taken over. It confirms its temporary nature and that its job was definitively done.
The fact that it served its active purpose by 2001 but then lingered on the books for another couple of decades before formal repeal really tells us something about how legal systems evolve and consolidate, doesn't it? It's like leaving the scaffolding up for a bit, even after the building's finished, just to ensure stability.
That's a great analogy, exactly. And its impact during its active life was profound. It served an absolutely critical role during that period of massive national transformation. It acted as a crucial pressure valve, providing a clear, accessible, and importantly, rapid pathway for individual and organizational grievances related to that monumental task of military integration and rationalization. Without such a mechanism, one that was independent, efficient, and cost-effective for the individual, these disputes could easily have festered. They could have led to widespread dissatisfaction, undermined morale, and potentially even threatened the stability of the new SANDF, and, by extension, the broader democratic transition itself. Its existence was really a testament to the foresight of addressing the crucial human element of such profound institutional change.
So for law students listening, this is really a prime example of bespoke legislation, crafted for unique historical circumstances, showcasing how legal systems can be agile and responsive to a nation's immediate needs. And for anyone interested in how nations manage change, it shows the sheer power of a targeted legal instrument to maintain stability and ensure fairness during what could otherwise be a very turbulent, uncertain period. And that wraps up our deep dive into the Defence Special Tribunal Act 81 of 1998. From its origins in that complex post-apartheid military integration, through its carefully designed expeditious procedures, and right up to its eventual planned repeal, it really offers a fascinating window into how legal systems can adapt to serve pressing, specific national needs during moments of immense change.
Yeah, what really stands out for me here is how this act demonstrates that not all laws are meant to be eternal. Some are specialized tools. They're built for a specific moment to address specific time-bound challenges. And then, once their job is done, they make way for other frameworks or are formally retired. It highlights the dynamic and evolving nature of law itself, and perhaps the wisdom in creating temporary solutions for temporary but absolutely critical problems.
So what does this all mean for you listening? Well, maybe next time you read about a major national transition or a large-scale institutional reform, whether it's in government, an industry, or even a large company, consider the often unseen legal scaffolding, like this act that has to be put in place. It's there to manage the human impact, resolve conflicts fairly, and ensure a smoother process. It's often the unsung hero of successful, stable change.
Absolutely, and it raises an important question to think about, doesn't it? What other historical instances can you think of where temporary, specialized legislation might have been essential, maybe for managing a complex societal or institutional change, perhaps after a natural disaster or a major economic crisis, or even during significant technological shifts? It's really a testament to the dynamic nature of law itself and its capacity to respond effectively to specific, time-bound challenges.